You're filling out a copyright application and you get to the part that asks for you to identify the author. And you say, oh, I'm just going to write myself. Wait. So if you created something original, you probably assume you're the author. But in copyright law, that term carries a very specific meaning, and it's not always what people expect. My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business. In this video, I'm going to break down the term author or authorship in 3 key areas under copyright law. That is the individual author, joint authors, and then authors under what's called work for hire. And then later in the video, I'm going to cover how you can document your creative process so that you can later demonstrate that you are in fact the author, should your author status ever be challenged. Please keep in mind, this video is just general legal advice. I'm not providing any legal advice to anyone or any form of representation. This is just to give you a general, but hopefully good foundation for understanding what the term author is under the copyright law. So under US copyright law, the author is one who creates an original expression that is fixed in a tangible medium. That last part is important because ideas alone are not subject to protection. In most straightforward situations, authorship is simple. Copyright law focuses on creative expression. If you sit down and you write a story, you write a book, you make a video, you make a painting, you are the author. But things get really involved or complicated when more than one person is contributing to an end creative work. There's 2 key concepts here. First, independently copyrightable contributions, and secondly, an intent to create a joint creative work. Each contributor typically has to provide a contribution that constitutes a copyrightable expression. If one person is only contributing maybe ideas or feedback, that alone may not be enough to constitute a copyrightable contribution. And as mentioned, there must be some intent among the group or the 2 authors to create some type of unified and copyrightable joint work. So under copyright law, traditionally, if a work is considered a joint work, then each of the authors has an undivided interest in the whole of the copyrighted work. For example, individual joint authors may seek to independently license the entire work to third parties, maybe even without the other joint authors knowing, but they still may be accountable to those authors to provide some type of payments under the licensing scheme. This is all dependent on the contracts involved, and this is why it's very important for joint authors to have some type of written agreement at the beginning as to how this entire work is going to be handled moving forward. So if you do find yourself in a joint authorship situation and you don't have a written agreement from the beginning with the other joint authors, you may be in a situation where you could be granting rights broader than what you had anticipated. And disputes in this area hinge on the facts of the case at hand. That's why this is not a blanket one-size-fits-all scenario. It's very dependent on the joint authorship situation. It's dependent upon agreements among the authors and whether or not they are or not written and when they were written. So the message here is that clear written agreements when you're about to start collaborating on a joint work are so important at the very beginning. So now I'm going to move on to another issue that is often misunderstood as far as the term author is concerned under the copyright law, and that is the concept of work for hire. Under this concept, the person who creates a work may not be deemed the author. Instead, it may be that person's employer or a commissioning third party if certain requirements are met. In the employer scenario, what's really important for consideration is whether or not the work being created was created within the scope of employment. So that is very fact specific and can get into the scenario of, well, someone created something while they're at their work, but maybe it was not within the scope of their employment. So again, this is a very fact specific situation. As concerns the commissioned work scenario, two specific requirements have to be met, and that is, one, the work has to fall within a specific statutory category, and secondly, there has to be a written agreement stating that the work is for hire. So if none of these exact requirements and factors are applicable in the employee-employer scenario or the third-party commissioned situation, it may be that the individual who created the work does remain as the author. So as I mentioned at the beginning of this video, I'm now going to address the issue of, well, how do I document to later prove that I am the author? So often people say, well, I have a valid copyright. I have a copyright registration. It's a presumption that I am, in fact, the owner of that copyright. Keep in mind that registrations can be challenged. And in fact, they are often challenged on the issue of authorship. So that's why it's important, as one creates a work, that a proper documentation of the creative process is made so that if authorship is ever questioned, there is documentary proof of that authorship. So I'm going to highlight a few ways that creators can document proof of their creative process and thereby their authorship. So maintain drafts and version histories that show how your work evolved over time. Save project files with embedded metadata, particularly time-stamped metadata, and keep notes and outlines or concept sketches that demonstrate how you developed your work, using email or messaging records that reflect your creative process or collaboration with other potential authors or even third parties that may not be deemed authors. Retain any contracts or agreements that you have that clarify rules and expectations, and particularly if you're getting into a scenario where it may be a work for hire situation. If the issue of authorship is challenged in a litigation scenario, courts often look to the totality of the circumstances and information available, not just particularly one document. Although one document may be persuasive, but everything is considered. My parting advice here is that when you're filling out that copyright form and you get to the issue of author, keep in mind it can be straightforward. It can be simply that, well, I created this work, I'm the author. But it also can be nuanced and maybe more complicated. So it depends on the facts at hand. So keep that in mind. And secondly, just because you get a copyright registration doesn't mean that the issue of author and authorship can't be revisited and examined during litigation that may seek to challenge the validity of your registration. Hey, if you found this video helpful, give it the thumbs up. It will help me spread the word to help other businesses and creators. And also, if you're not a subscriber, please subscribe and certainly share this video with other creators and business owners who may find it helpful. And if you like this video, you may want to check out this one as well.